Hello, my friends. Today I would like to discuss with you court judgment from the 4th of August, so-called contact judgment. During this hearing, the question was how many times per year I can see my son. I asked for a weekly contacts. Medway wanted to keep decreased contacts 4 times a year. Interesting to note that they just cancelled few contacts and they put it as a fact over the judge, asking his approval, which they received. Hi, thank you for joining. It's quite interesting judgment, which to my view shows total lawlessness of what's going on in the court. Just a second, show you something. For example, you see here, second application was whether my son is allowed to read court documents. He's 13 years old, very smart boy, coming 14, studies at grammar school. So, when he was taken into care, he clearly said he doesn't know why he's in care, doesn't know why people are so much worried about him. After a year and a half, I believe Medway wanted to do their best to brainwash him, and by no means categorically they didn't want he saw court documents, judgment or social worker submissions, because if he would see them, he'll be absolutely horrified with what he could see. So my submission was, as you can see, discrete issue of whether my son could read court documents, including judgment. Force of my submission was that he should know what is going on, why various decision was made. So he was denied this possibility. It was opposed, you can see, very strongly by Medway and Guardian. Why? Because he was already informed in a child appropriate manner. How to say to a child most appropriate manner why he in care and why he see his father, his single carer who cared him all his life, 4 times a year. There should be some explanation. So I cannot really imagine what explanations they could give to a child. Probably they lied to him that I need some treatment, you see. So I made you aware about it. It was refused, so my poor child might never know judgment until he come back to my care. Okay? So why he need to read anything if he has people who will provide him with all necessary information in a filtered way? Let's go next. Second point I want to make. It was a point I did not want that social worker, BC Archer, give any evidence on the grounds that she didn't comply with the court orders. My friends ask you, what is the sense for any court order if Children's Services has any chance to ignore them? BC Archer, she didn't let me have contact with my son on the 8th of September 2015. Later on, as I could see from judgment of Judge Karat, which was just recently transcribed, she didn't make this 2.5 hours, which was meant to be. No, she didn't do it. She just ignores it. So a question arises, whether anyone who is breaching court orders should be allowed to give any evidence. I pay attention to another judgment, reasons for allowing pilgrims to appeal. It was a decision of a Judge Cameron not to allow me and my son to attend together synagogue. We can see here, again, statement the same B-Satchero. Local authority is clear, the child does not want more contacts and find his father very intense, approach difficult, embarrassing. Be not in a child's best interest to be out in the community. Out in the community with the father in an uncontrolled, untested, unknown environment. So Judge Cameron called Passover, as you could see and hear, uncontrolled, untested, unknown environment. I believe my disclosure of these documents, although I don't see reason why it should be not disclosed. This is a free country, and I don't give my son's name. I give judge name. I don't think the judges should be afraid of judgments if they are fair. It should be reason for committing me to prison on the 26th of October. So more and more and more this hearing reminds hearing in some communist countries. But in that countries, people were tried only if they were enemy of regime, political opponents, so to speak. But from what I know, being brought up there, parents never were tried just for the right to be with their children. Or we can make a parallel with some maybe some extreme Muslim regime which tries their opponents for what is alleged to be a crime. Some maybe espionage, alleged espionage, or some drug crimes or whatever. But I don't remember that they are really tried taking children in under protection of the government. I don't remember these cases. So Judge Cameron, she called synagogue attendance, synagogue as unknown, untested, uncontrolled environment. Given that we attended with my son already on a quite regular basis, all this year he stayed with me, I find this submission not even inappropriate. To my view, it was said by someone who doesn't like synagogue, doesn't like this ceremony, who contemptuously call it uncontrolled, untested, unknown environment, an event which exists more than 3,000 years and which my son and me attended before. My friend, just remember that, because it could come anytime to any of you. You might not be allowed with your children to attend church or mosque or temple, if it will be followed with the same logic. Okay, coming back to judgment from 4th of August. Anyway, I can see 1 page, 2 page, but there is no any justification why content has to be decreased. But I don't think it is really, how it is possible that father and the son want to see each other more, and then comes some shady social worker and judge from above what is the best of child interest. And this social worker, she is the one who is breaching court orders, because in the previous document she was lying to the court, saying that my son doesn't want to see me more. It was a lie, and it was proven even by guardian and by all father's submissions. So we see here someone who is lying to the court, lying quite persistently, and still the judge says that he prefers your evidence, professional evidence, to evidence of father because she is a professional witness. There are some points being further discussed. I was blamed that I tried to show my son UN Convention on Human Rights. It's incredible. There is a Lord decision, House of Lords from 2010. UK ratified this convention. It says should be distributed at libraries, at schools, and then some social worker at BCI to come and said, no, it's not in the child interest. How she put it? Hang on. Just looking for a page. There is something, it's written that social worker doesn't think it's for this child as justice, as my son. This convention could be known. I told judge that I can't accept judgment of Judge Hamilton because new circumstance arrived about my hearing. And it's very clear that I do not need any medical help, any medical attention. Judge Karat, he just simply ignored what I told him. That's how it's being operated. If there is a cold hard evidence, 3 letters from professionals, it's just being ignored. So I'm blamed that I don't agree that my child should stay in care. Sadness of this non-acceptance by the father and with the obsessiveness of his own agenda is my son is being deprived of the loving relationship with father. My friends, I can't really believe it. So I'm obsessed with my own agenda that my son should stay with his single carer, with the father, and they call this obsessiveness with my own agenda. I mean, those elaborations, I don't know which regime, which country could it be that if father wants his son to come back home, it's called obsessiveness, and it's called his own agenda, and it's called adult conversations, and it says that it deprives my son from relationship with his father. I mean, I think it's only Council of Europe who should deal with this extreme violation of human rights. Hopefully like in a Bodnario case. Otherwise, it will happen again and again. Now, that one happy aspect of the case is my son is flourishing in foster care where he is cared for by very able parents. So by able parents who get £500 per week, he calls them professional parents, and his own father is some sort of amateur parent who give him all his life, his amateur parent, yeah? Maybe I should get a license to be a father. It's ridiculous. So these people will teach me how to behave at contact. So they write me even letter, how I have to behave at contact, emphasizing how to behave. So some shady social worker who is lying to the court, who had some CCJ judgments against her, she will teach me how to behave at contact. It's absolutely incredible. There was also a judge asked me about two things. He ensures relation to context that he takes on board criticism and does not raise his agenda and protests at contact sessions. And secondly, that he tells his so-called supporters to desist and to allow a proper relationship to be established between my son and the father. I'll pass this. They already know judgment, my supporters. There were protests organized in Milan, in Madrid. There will be protests in Vienna as well. Supporters want my son come back home to his father. I don't see any justification to that I should see my own father, my own child 4 times a year. It's a matter of child cruelty, so I respectfully would be happy if Medway finally would start work together with me for the best interest of the child. I'm not going to just sit and wait till next meeting with my son, when I'll be not even able to tell him anything which I want to tell him. He'll not be able to see even court judgment. And of course all blame will be put on me. I kindly appeal to my supporters, intensify efforts, follow me on Twitter, on Facebook, on YouTube. Let's make people know that my son will come back home. It's difficult to fight against this overwhelming people. But I will do my best, and my supporters will do their best, even if it cost us years of our life. Thank you for your time.